because intellectual property is something that I get questions on all the time. It was one of the biggest topics in our Ask Me Anything panel this morning. Oh man, Aaron's here, and I said I saved the best for last. This is what I get. I'm going to start screening attendees. Just kidding. Aaron, thanks for checking this out. And thank you for your presentation. Someone did say, though, in our previous session that Aaron and I were the Batman and Robin, and I would like to know which one of us is Batman and which one of us is Robin. So if someone can answer that question below, I would appreciate it. Who knew attorneys are so funny? I have told everyone I have 6 months worth of dad jokes lined up that I have had no platform to share with the world. So you're just getting all of them today. This is what the deck gets for giving me 4 hours of platform time. So you're welcome. Aaron, thank you for that. I appreciate it. As a side note, I don't really watch superhero movies, but I watched Spider-Verse or Spider-Man Into the Spider-Verse the other day, and I am pretty hyped on that soundtrack. So that's totally unrelated to law, but related to the conversation of superhero movies. Okay, so anyways, we've had a great day. We had a legislative update. Yeah, the soundtrack is so good. I had to go to court a few weeks ago. If you know me, I don't go to court normally, but I wanted to get hyped up because I was going to court, and I listened to the Spider-Verse soundtrack. So if you need to get hyped up for anything, I highly suggest the Spider-Verse soundtrack. But we've had a great day. We had a great day of legislative updates. We had a great day of Ask Me Anything. We just had a really lightning round session with Aaron on entity basics, which I don't even know how he got through that much information so quickly. And now we have Matt, who's going to give us all of the intellectual property basics. This doesn't officially start for a minute, and I want to give people time to get out of their last sessions and into this session before I introduce Matt. But truly, thank y'all for your continued support of this track throughout the day. I know a lot of you have been going from session to session, and we appreciate you so much. It's been a little more of a back to basics year for the legal track. We've been trying some different types of events over the past couple of years, and I hope and my goal for the track this year was really for this to be a best of the best kind of events. And y'all have seemed to enjoy it. And like I said, your engagement has really been just beyond expectation. Y'all have come to every session with so many questions and so many insights and so much to say, and that really does help as a speaker. So thank you for that. It is officially 3:45. I have no small talk left, so I'm going to go ahead and officially introduce the session now. Welcome. This is our 4th and final session for the legal track today, and it is going to be a good one. I have no doubt.
Uh-oh, am I on? Can anybody hear me? Jessica froze and dropped off. Okay. All right. Well, hello. We've lost Jessica, but in that case, I'll go ahead and start and introduce myself. My name is Matt Acosta. I am a partner with the law firm Platt Chima Richmond. Hi, Jessica. You're back. I just started introducing myself, if that's okay. I have been practicing intellectual property for 12 years now. Back in the day, I started out as a litigator, and I've continued to do that and litigate intellectual property and patents, trademarks, and a little less in copyrights. And then a few years back, I started a consulting gig, basically with small businesses and startups, and I've continued to do that, prosecuting their trademarks, serving as outside general counsel on intellectual property matters. And I've had a lot of successful startups over the years, watching them grow, and that really brings me joy. And so I decided to do this, and I love introducing startups to intellectual property because I find that there's a lot of value, I think, to small business owners that are just getting into the field that they just don't see in the intellectual property realm. They know basically about some of these, like trademarks and patents and trade secrets. They've heard that word, but they don't really understand the kind of value that those particular elements of intellectual property can bring, and that they have already when they're just starting their business, and how to protect them. So with that introduction, the overview of what I'm going to talk about is just basically what is IP, why it's important, and then we're going to try and breeze through as quickly as possible important points of trademarks, patents, trade secrets, and copyrights, and hopefully have some time for some questions at the end, because I know that's the important part. Okay, so intellectual property. What is it? So it's basically anything that's not real property, the land, or tangible property, anything that comes from the human brain, thought, ingenuity, etc. But it is still considered personal property for basically any other legal purpose. So if you're distributing property in your divorce, it's considered the same thing as like a chair. So your patent, if it's being distributed in your divorce, is treated basically the same as your rug, because it's considered personal property for all intents and purposes, except if there's some special legal rule attached to the intellectual property. So why is it important? It provides legal rights for people that, basically their business is based on thoughts and not creating tangible things. It provides economic value to businesses, and it promotes sharing and transfer of ideas for money. So you're able to sell your ideas rather than just your tangible pieces of property. Okay, what are the types of IP? The major types are trademarks, patents, trade secrets, and copyrights, as I've said before. Okay, so the value that it adds is incredible, especially in the US economy, which is growing more and more towards an intellectual property-based economy every single year. The last major study that was done, it was in 2016, and it found IP-intensive industries accounted for 6.6 trillion in value, which was a third of the U.S. economy, and that's only gone up since then. So at this point, it's probably more than half of the United States economy is based on intellectual property. The intellectual property holds value, and so it's really not necessarily depreciable. So it's not like a car. When you take it off the lot, it automatically depreciates. No, it's something that holds value and typically appreciates as long as you're taking care of it. But if you don't take care of it, if you don't service it, it can very, very quickly degrade in value, and sometimes almost immediately degrade in value if you're not servicing it or treating it right or making sure that you're doing the appropriate things to protect your intellectual property. So let's dive into trademarks first. Okay, so what is a trademark? At its very basic, a trademark is a designation of source, and it's also the holder of goodwill in your business. So it's actually, most people don't know this, is that a trademark is there to protect you, the business owner. So it makes sure that people can associate your goods and that other people, other business owners can't steal your brand. But it's also there to protect the consumer. So like in the situation of counterfeits, so the consumer knows that It's buying from your brand, the real brand, and not from some counterfeit brand, because if they buy from the counterfeit brand, they could be endangering themselves. They're not going to get the right thing, et cetera, et cetera. So there's actually a dual purpose for trademarks. And ultimately, it's what holds the goodwill of your business. So all that money that you're pouring into marketing, you can think of that. Yes, you're getting, you might get an extra customer, and that's an extra sale for your marketing dollar. But also, that marketing dollar is actually going into the equity of your trademark. So that has an extra purpose, that marketing dollar that you're spending, because it's also increasing the value of your trademark, because your social presence on social media, even if you're not selling that extra widget to somebody, well, people know your brand better now. Even if they're not buying you, they know your brand. Maybe they're talking about or something like that, and their grandma wants to buy your product, right? So making your brand known out in the world is another value of your marketing dollar. And in addition to that, that value is your goodwill. And so that's kind of the equity that's being held by your trademark. And that's something that's actually tangible and something that you can sell. So there's three flavors of sort of trademarks. Trademarks, that word, is for goods. Service marks, for services. And then there's trade dress, which is actually the way goods and services are. It's the way that something can look, and we'll talk about that in a second. I'll show you some examples. So trademarks or trade dress or service marks, they can take a lot of forms. They can be words, they can be designs, they can be actual colors. The University of Texas actually has a trademark over that particular flavor of burnt orange. It's called Texas Orange, and other schools have trademarks over particular colors as well. So do particular companies. You can actually trademark sounds as well. And so anything that distinguishes your goods and services from other goods and services, and acquires distinctiveness over time, so that people recognize that particular mark in connection with your goods and services, that can be a trademark. And so, those are, let me go back. So this Coca-Cola bottle is actually an example of a trade dress. So everybody knows that this particular shape of bottle is associated with Coca-Cola. So that's a good example of a trade dress. Also trade dress is Taco Cabana. So just the way Taco Cabana is set up, that sign, the way its store looks, that's actually a trade dress of Taco Cabana. That there was a very famous case called Taco Cabana versus 2 Pesos, where Taco Cabana sued 2 Pesos. 2 Pesos said, wait a minute, you can't have a trademark over the way your store looks. Come on. And the court said, oh, wait, yes, you can. Yeah. Anyway, so I like to use the example of the iPhone, because basically everything on the iPhone is a trademark. And of course, it has a lot of patents associated with it too, but it can be words, designs. So Facebook by itself, just the word Facebook, that can be a trademark. But then also the way that Facebook is written is a logo, right? So that can also be a trademark. The way it's written, the particular design, the way Facebook is written. So those are 2 separate trademarks. Also, Instagram or Snapchat, the Snapchat logo by itself, that's another trademark. How do you have a good trademark? So it has to be, how unique is it from other people's trademark? How distinctive is it? So distinctive is different from unique. Distinctive means how removed is it from what kind of goods you sell. And we'll talk about that in just a second. And then you have to use it properly. So the question I get most often is, okay, if I'm selling shirts, can I put my trademark on the actual top of the shirt, the front of the shirt, and then call that my trademark? Well, usually no, because they call that, they say, the trademark office says that that's just ornamental. That people don't see that as a trademark, they just see that as the design on the shirt. You know, that's just what an artist would put on their shirt, and they're not going to think, oh, the shirts are made by this trademark. They're going to say, oh, that's a shirt with a design on it. So usually the trademark is actually what goes on the tag. So Under Armour started by making shirts and have a trademark by putting their Under Armour trademark on the tag of their shirt. After a while, they're allowed to put it on the front of their shirt and still retain that trademark. But that gets us a little deeper than we'll talk about here. So this is distinctiveness. You have generic, which is not, you can't trademark the word salt. It's if you're selling a particular brand of salt. Then there's descriptive. You can't trademark these either. Quick print, because you know they print quickly. That's exactly what they do. Computer land. They are a place where you buy computers, so that's too descriptive of the business that they do. Then they're suggestive. You can trademark these in certain situations because they are not descriptive of what you do, but you sort of can figure out what you do based on what they say, like chicken of the sea. Okay, well, you know, tuna, maybe it's kind of like chicken and it comes in the sea. And then there's arbitrary, which is like Apple, has nothing to do with computers. And then there's fanciful, which is the strongest kind of trademark, which is like a totally made up word. Nobody's ever heard of it before. You just made it up out of nowhere. And so it has no association with anything whatsoever except for your brand. All right. So what rights do you have in a trademark? You have sort of a halo of rights, and you don't have to register a trademark to have rights in it. Trademark rights are based on use. Where are you using them geographically? What goods and services are you using them with? And how are you using them? Are you using them appropriately? Are you using them so people will know that your goods and services are coming from you, and not just, like I said with the shirt, that you're using them ornamentally? So automatically you have common law trademarks. So if you're using a trademark correctly and consistently with your goods, you automatically have a common law trademark rights, as long as somebody else is not using your mark competing with you. So you don't have to register, you just have those rights, but they're very, very limited. They're limited in the geographic scope and in the goods and services, exactly where and how you are selling those goods. Then you can get a state registration. So you apply in the state of Texas, you can get a state trademark registration that expands, even though you're still selling in the same limited area, that expands your trademark rights all the way to the state of Texas, and it gives you a better halo into a more general category of goods and services. Then a federal registration does the same thing essentially, but it expands the geographic area to the entire United States. We got a question. Is Windows trademarkable because Windows are not the actual product? Yeah, it's a strong trademark because Windows essentially has very little to do with computers, although at the beginning, way back when Windows was just starting out, it was a company that created an operating system with Windows. So it was actually, to some extent, descriptive of what Windows actually did, the operating system. And so it took a little bit for it to actually convince the trademark office for it that people associated it with a particular brand, because originally it was sort of descriptive of the software that they were actually selling. It has over time become a particularly identifiable trademark. Okay, so likelihood of confusion is basically the test for trademarks. I mean, that's the rights that you have in a trademark. How likely is a person to be confused by your mark, between your mark and another potentially infringing mark? And there's lots of ways that something can be potentially confusing. It can sound like your mark. It can look like your mark. It can sound kind of and look kind of like your mark. There's a slew of different factors that the trademark office looks like in determining whether something is likely to confuse. Okay, so what is the federal registration process? So there's two different types of applications. You can apply for a trademark that you're already using, and you can also file another type of trademark application for something that you intend, for a trademark that you intend to use, so you're not using yet. And for an intent to use application, it gets examined just like a trademark application for a mark that you're already using, but after it's approved, you have actually 6 months to start using the trademark in commerce and provide proof to the trademark office that you're using it before you actually get a trademark registration certificate. So that's really the difference. And the examination process can take anywhere between 6 months to a year, and if you're filing a intent to use application, it can take even longer. And there's all kinds of reasons that the trademark office can reject your application, and they often do. And that's really why the value in an attorney is because there's all kinds of reasons. It's very easy to file a trademark application, but throughout the examination process, you can fall into a lot of pitfalls. And then ultimately, when you file, you need to recognize that there's a lot of nuance in trying to get the broadest amount of protection you can, while also not running into pitfalls so that you're going to get rejected by the examiner. Because literally, this is the book that the examiner uses to reject your trademark. It's pretty thick. So after you finally get a trademark, you have to actually maintain it. And this is where a lot of people lose their trademark because after 5 and 6 years and 9 or 10 years, you have to file a statement that you've continued to use your trademark for that period of time. And they don't really remind you very well in the trademark office. You just have to do it. And if you don't do it, then they cancel your trademark with no recourse. You just have to file for it again. You have to go through the process again. So it's very important that you keep an eye on it and make sure that you maintain it after those time periods. I also want to mention that you should not, unless you have a registered trademark certificate in your hand, use that little R with the circle around it because it is actually illegal, and you can lose a trademark or actually get sued if you are using the registration symbol with the circle around it without a registered trademark. You can use the trademark symbol with the circle around it if you consider your mark that you're using a trademark, and that tells the world, hey, I consider this thing a trademark. You shouldn't use it, but you shouldn't use the registration symbol. Now I'll talk a little bit about patents. Okay, everybody knows about patents, but this is probably the most complex area of intellectual property law that there is. You think the examination process, and I showed you that big book for trademark examination. You think the examination process for trademarks is difficult. There are 3 volumes as thick as that book that I just showed you for patent examination. So it's three times as thick for patent examination, and it's actually a very, very complex area of the law. And so if I highly recommend at the front end, if the question is, can I secure a patent all by myself? The answer is maybe, but it's rolling like a 100-sided die, maybe a 1,000-sided die to try and secure a patent. And at the very end, you're probably not getting the best product that you could have gotten, even if you're able to secure a patent all by yourself. So it's a very good idea at least to consult an attorney about whether you have a patentable idea or not. So what is a patent? This is a deal with the government. And the deal is you disclose your invention to the world, and they give you exclusivity. So there are no secret patents. People talk to me, and colloquially they say, oh, people are hoarding patents and keeping them secret. But that's exactly the point. There are no secret patents. They're all disclosed. That's the deal you're making. You're disclosing to the world what your idea is. And after the patent expires, it's the world's idea. And you can't keep it secret. I have a question, and I was going to address this, but I'll address it now. Can you secure a provisional patent on your own and then file the formal through your attorney? So yes, you can file a provisional patent application. It does not get examined, so you can absolutely file it. Remember, you have a year after you file it to get the full utility application on file. However, big however, you still should consult an attorney before you file a provisional application, because once you file a provisional application, you cannot amend it. You can't amend it, and you can't claim anything broader than it in your patent. So in your full utility application, in your claims. So once you've committed yourself to filing that provisional application and putting what you disclosed in that provisional application, you can't try and broaden the subject matter that you're claiming. So if you missed something, if you say ultimately, oh, there's this extra thing that I forgot to put in there, if after you make that filing, you figure out something else that you want to add to the invention or something to that nature, then you're not going to be able to amend it. You're not going to be able to claim more. You're going to have to file another provisional or another patent application. And also, you may have invalidated your invention because you filed that provisional application earlier. And so there's just a lot of pitfalls that you can get into. It's a powerful tool. You can put patent pending on your slideshows if you do file it, but it's definitely worth at least consulting with an IP attorney before you file your provisional application. Okay. So you get protection for approximately 15 to 17 years. The term is actually 20 years, but it's going to take between 3 if it sails through and 5 years to actually prosecute. If it's really hard and you want to spend the money, it could take up to 10 years, but you don't get that time back. And you have to have the patent to enforce it. So it ends up being, really 7 to 15 years. There's 3 flavors: utility, design patents, plant patents. Basically, design patents have a shorter term, and they can't have anything useful associated with them. They just have to be purely a design. But most people, when they think of patents, think of utility patents. So we'll talk about those. So they're issued for any new useful process, machine, manufacture, composition of matter. And this is how you get them. This is the test. This is the statute. This is basically the main statement of what it takes to get a utility patent. And the important parts are: it has to be new, it has to be useful, it has to be a process, machine, manufacture, composition of matter. And so we'll talk about each of those, but the new quote unquote shiny object, and what people ask me about most, is software patents, and a case called Alice versus CLS Bank. So there has long been, based on that quote, useful process, machine, manufacturer, judicial exceptions to getting patents. You can't get them over laws of nature or natural phenomenon, and the most important, quote unquote, abstract ideas. And that's where Alice from 2014, the Supreme Court case, came in. It used to be very easy not to be an abstract idea. And now it's very hard to not be an abstract idea. Especially if you're trying to get a patent over software, pretty much you can assume you have an abstract idea if you're trying to get a patent over software. So what is an abstract idea? The courts use two steps. First, they say, is it abstract? Such as, is it an algorithm? It's software, so of course it's an algorithm. Is it a method of computation? Once again, it's software, or other general principle. Okay, so what we litigate, right? And this is I find, because this is what judges actually do, and this is what the case law actually says, is that basically if a superhuman could do it, even though people can't do it, then it's still abstract. So relational databases, right? They deal with terabytes of information per second, and are able to organize that into millions of different categories all at the same time. But the courts say, well, a superhuman could do that on a spreadsheet, right? Or with a pencil and a piece of paper. That's just applying that basic principle to a computer and doing it really fast. So that's an abstract idea. So what they're doing, a superhuman can do it. They're boiling it down, and you have the claims of the patent. Basically, if you're claiming, or if your idea it boils down to, and you have to really think objectively about this. If your idea boils down to, okay, I'm sending data from A to B, I'm receiving data from B to A, I'm calculating things with data, or I'm analyzing that data, at the very abstract of what my invention is. Yes, it's much more complicated than that. Yes, I took millions of hours to code it. Yes, I'm super smart. But when you boil it down, if that's what it is, then the courts are going to think it's abstract. And the Federal Circuit, the appeals courts, who ultimately have control of these things, are going to think it's abstract. The current patent office doesn't really like this case very much. So they're trying to step away from it, but there's only so much they can do because they have to follow the law. After that, if they still find it's abstract, there's a bit of a saving grace. They say, oh, okay, even if it's abstract, is there something extra that embodies a significant inventive concept? So it has to be significant over what came before. And so this essentially, for software patents, it has to tie to something new, up and coming, that's either physical or that has really, really advanced the usefulness over what has come before, what we call the prior art. So a good example is this case against Fitbit. So Fitbit was sued, and basically it was sued by this company, and it said that its Bluetooth method for connecting via Bluetooth between the Fitbit and the phone, and then publishing the data on the internet through its app, that was violating this other company's patent. And the Fitbit said, no, this patent is invalid because it is an abstract idea. So the court said, yes, it's absolutely an abstract idea. This patent is absolutely an abstract idea. However, it is saved by step 2 because the prior art at the time this patent was filed, the actual devices didn't have iPhones. So they had routers within the actual device, and they connected to the internet by themselves. They had all this extra bulky technology in them. They were not as small as a Fitbit. You could not wear them on your wrist. You could not go running with them. And so that was the significant advancement. And therefore, even though it was abstract, it still was patentable. All right, so I have tons of good questions. Let's see if I can find one that, let's see. Okay, I don't think I have one right now, but I keep seeing stuff pop up, and it's in the corner of my eye, so I'm thinking it's a good question. Okay, Bruce has a good question. Supreme Court came down against abstract idea in 2014, so you can no longer patent something basic like a new software hash algorithm, but NASA just got a patent granted for a faster, cheaper route to the moon. That is just math, the same thing as a computer algorithm, so what's the difference? Okay, so like I said, there is, that step 1, step 2 analysis, so you get saving grace through that step 2, but then also there are very other nuanced ways to claim your invention. And basically also another way you can do it is you can tie your software to something actually physical, or you change the nature of how computer networks or how computers themselves actually work. And that is not considered abstract within itself. So it's not just the use of databases to process data or the internet to send and receive and organize data. It's actually changing the nature of how computers work in the first place. So for instance, if you took a computer without a graphic user interface, right? And you invented a computer with a graphic user interface, even though the graphic user interface is software, right? Well, that opens up a whole new world of computing and interfacing with users. So it's really changed the nature of computing and interaction. So even though it's software, it's still something that that could be patentable. So it's not that all software is abstract. There are many different situations where software can be patentable. It's just a lot of different situations where in fields of software are going to be considered abstract ideas. So you have to rely on step 2 to really save you, and that's going to be fairly difficult and going to be nuanced either by an attorney, or it's just you're not going to be able to do it given your invention. So I'll go through this really fast. Novelty. This is fairly simple, is that it has to be new. It cannot be the same as invention as something that came before. And this is not just other patents. This is also compared to any other publication that has come before the patent that you filed. So it's not just compared to others patents that have been filed. It's also compared to any other publication that's out there. That's a question that I get pretty often. non-obviousness. This is the number one rejection in the patent office. And this is, they take one reference, they take one patent, they take another reference, another patent, they take another reference. It can be more than two, it can be more than three, it can be more than four. And they put those all together and they say, okay, based on all these 3 or 4 references, it would be obvious to combine these references, these different technologies. And if you combine them, it would be obvious to think of your invention, and therefore your invention is obvious and invalid and shouldn't be patented. And so this is the number one rejection. Usually it's based on 2 references. And so there are various ways you can overcome this, but it is the number one rejection. So it's not just that you're rejected for inventions that came before, single inventions that came before. There's also this other halo where the patent office gets to put 2 or more inventions together, combine them, and say, okay, based on this combination, your patent is actually invalid. So what are the main parts? There's the title of the patent, there's the key dates when it was filed, and there's the inventors. You have to put all the inventors. If anybody contributed anything to the invention, you have to list them as the inventor. The patent can be invalid otherwise. The ownership can be all screwed up otherwise, and you can embroil yourself into many, many, many lawsuits, or be unable to enforce the patent at all if you do not get the inventorship right. So it's very important that you include all the inventors. There's the written description, where you describe the invention, and there's the claims, which are the effective part of the patent. That's what's litigated. That's what you have to use to show infringement. That's what the patent office examines to find whether the claims are valid or invalid or based on obviousness. These are really the effective secret sauce of the patent. And they start in numbered paragraphs at the very end of the paragraph, and they at the very end of the patent they say what is claimed is, and they say like 1, 2, 3, 4. There's method claims and apparatus claims. Method claims are a method for step 1, step 2, step 3, step 4. Apparatus claims are what a styling tool comprising a handle, a U-shaped hook. You know, it just describes the thing, whatever it is. So we'll skip over the patent review process. I'll just say it's long and complex. Trade secrets. Okay, so a trade secret, this is basically the polar opposite as a patent. A trade secret can last forever. But you can't disclose it to anybody except under certain circumstances. You have to keep it secret. And it also, the other reason why it's very different than patenting, I can't talk today like Jessica, is that it can basically be anything. Under the Texas Uniform Trade Secrets Act, there's 3 requirements for a trade secret, and this is the laundry list. A trade secret can be all forms and types of information, and then it lists out examples. And these include any plan, compilation, program, device, financial data, list of actual potential customers or suppliers, et cetera, et cetera, et cetera. And so, essentially, I think most businesses start out with trade secrets. Most businesses very quickly build trade secrets. And most businesses lose a lot of their trade secrets very quickly. Most businesses don't even know they have trade secrets. So it's important to try and identify what trade secrets you're building at a regular basis. And it's not particularly difficult. You just have to identify what is really giving you a competitive advantage that your competitors don't necessarily know about your business. And those are the other 2 tests. It's not generally known to the public or discoverable by reasonable investigation, and it gives you economic value because it is secret. You also, to keep it, you have to keep it secret. So how do you keep it secret? Well, it depends on the circumstances, but what I recommend is essentially what you have to do is you have to make sure that you keep it within a tight-knit circle, and that tight-knit circle absolutely knows that it is secret. They have to be under a duty not to disclose the information. And you also have to keep it to people who only need to know the information. That means that when you're writing an NDA for employment, best practice will be, once you've identified your trade secret, to actually put the particular types of trade secrets that are in there. Not that huge broad language that we will give you trade secrets and you will have to keep them secret, because nobody knows what those are, right? They could be not trade secrets, they could be trade secrets. There's nothing really particular in them. You need to make sure that your employees or your contractors or whoever you're providing information that's potentially a trade secret, they know that this particular piece of information or this category of information is going to be a trade secret, and that they need not disclose them. The NDAs should try as best as possible to identify that particular type of information. I think Jessica was talking about earlier, your investors, do you need to give them NDAs in all circumstances? Absolutely not. They know that whatever information you're giving them shouldn't be generally disclosed to the public, et cetera, et cetera. And so that's basically all you need in that situation. You don't need an NDA for every single situation. It's only when you start, gathering employees, talking to direct competitors, talking to contractors, et cetera, at that point, when you start distributing that sort of secret sauce to people, at that point you should be trying to get NDAs if you think that you're giving away or disclosing that kind of secret information that you've identified. Once again, you should be trying to identify it. And so we will go to the next. What are the downsides? There is no protection against reverse engineering. It doesn't protect research and development investment, and it is harder to market trade secrets. However, it is far less expensive than the patenting process, and it is not as fraught with danger, and it probably has a better ROI in most circumstances for trade secrets. Okay, so quickly, copyrights, they're automatic. If you have an original work of authorship, it's very easy to have a copyright. You don't have to do anything. You don't have to mail things to yourself. There's all of these like voodoo things floating out there that people have told me about, like mailing it and not opening it and dating it or something like that. You don't have to do any of that. As long as whenever the creative work is in a fixed medium, when you write it down, when you type it, when you code it, any of that, you automatically have the copyright in it. Yes, putting the copyright circle symbol is good so the world knows it's copyrighted, but that's not even necessary. It's automatic, and it belongs to whoever the author is. We'll talk about no additional circumstances. So there's no need to register. You do have to have a registration if you're going to sue somebody. The term is very long, 95 to 120 years in certain situations. Okay, so I do want to talk about ownership and transfer. Employees' works are owned by the employer. So if they're an employee and they create an authorship, a copyrighted work in the scope and course of their employment, then the employer is going to own that. But if they're a contractor, then the contract specifically has to say that they are doing a work for hire. for the person contracting them to own that copyrighted work. It has to have magic language, and so you have to be specifically careful in the context of when you're getting, for example, a design from a marketing firm that they're creating for you for example, your trademark, that they assign all those rights to you, because the copyrights in that design aren't necessarily yours if you're contracting with that marketing firm. Also, make sure the marketing firm is not just pulling stuff off Adobe and using that for your logo or part of your logo, because that's happened to my client before and it's not great. Copyrights can only be transferred through written instrument. So it has to be in writing. You can't transfer them orally. So nobody can transfer your copyright through oral agreement. However, it can be evidenced in writing, even though it's oral, through a later writing. So you can say in a writing later, I transferred a copyright to you last week, or something like that, or all my copyrights to you last week, and you can say that in a writing this week, and the transfer will be effective. However, copyrights can be licensed orally. You can also you can also license copyrights in your terms of service, and this is important in a lot of software companies, a lot of internet companies, especially if they're posting other people's content. This is Snapchat's terms of service, where essentially they say you're licensing everything you post to them. And this is just what you sign up for when you sign up to Snapchat. You give them rights in all your copyrights. Now, they can get in trouble if they misuse that information, because there are restrictions on exactly what you can do with other people's information online, and they can be popped for deceptive trade practices if they misuse it, especially if they are not in the business of licensing works of authorship from people, and they're trying to profit off of those works of authorship, rather than just being an online Snapchat company. But it is important, so they can run their business, or you can run your business with other people's content, that you're getting some sort of license for distributing or using any content if you're going to use it for any other purpose whatsoever. And so that should certainly be at least part of your terms of service. And with that, I will take questions. Let's see.
Good job. There's two. Carla has two good questions. And when you get a chance, you can review my high-level jokes that I made and just take a chuckle at those at your leisure.
Okay.
But Carla's questions are actually good, so focus on them.
Okay, so Carla, let's see. I'm sorry, I'm like 8 million DMs behind. Are letters arranged in a certain way copyrightable? I was told that letters cannot be copyrightable. Letters, if you mean individual lettering, then yes, in certain circumstances they can be. So the best way to copyright letters, so individual letters, so for example, A, the letter A. The best way to, if you want to copyright over the letter A, that is what you want your copyright to be. I would advise before you set yourself in stone, that you want to copyright a particular logo with the letter A in it. You don't want to try and copyright the letter A, because you're going to run into some trouble in the copyright office with that. Is it necessarily not copyrightable? Well, single letters are, for the most part, not going to sail through the copyright office, and they're not going to. Sorry, are we talking about trademarks or copyrights? Did I say?
Rights.
Copyrights. Okay. No. So I was talking about trademarks. So let's answer your real question about copyrights. So individual letters, no, are not copyrightable because they're not works of authorship. or they're not creative enough, actually. They're not creative enough to be copyrightable. Now, if they are stylistic works, or if they're stylistic letters, like I was saying, so if they're like fanciful drawings of the letter A, then yes, they can be copyrightable.
Matt, I think Bruce has a good question that I know comes up frequently about copywriting software.
Yes, all software that you create is automatically copyrighted like anything else. That is a original work of authorship. It is considered a creative work of authorship. And so, yes, the question is, if I copyright my abstract idea software versus patent, does that do me any good? So the rights that you have in that essentially are people cannot copy or make derivative works out of that software. So derivative works means that you have this halo of protection, so they can't take that software, having looked at it, you know, and then add to it, modify it, use it to change it, etc. So you do get that halo of rights and certainly not copy it, right? Or make copies of it and distribute it, try and license it to other people, et cetera, et cetera. So you have those rights in it. However, what it doesn't protect you from doing, or other people from doing, is seeing what the end result of that code is. So if it does X, like whatever it does, and that's the utility of it, right? It doesn't stop another coder or business from being like, oh, I'm just gonna code something that that does X too. And just having seen the result of what your code does, as long as they're not looking at your code and copying it directly, then they're fine doing it. In order for it to be copyright infringement, they need to actually be looking at your code and copying it or making derivative works out of it. If it's a patent, then it doesn't matter if they've seen it. It doesn't matter if they've seen the code. It doesn't matter even if they've seen the end result. If they're doing it, if they meet the claims of the patent, then they're infringing the patent. All
Okay,
right.
and we're going to take one more question, then we have to wrap up because we're about to get kicked out of the room.
Okay,
So,
Carla had a question about transferring copyrighted items.
yeah,
So I can transfer my copyright items to my son. How long are they protected? Are they protected for life or indefinitely? Yes, you can transfer your copyrighted items to your son. They are protected by the end of your life plus 100 years. So it'll probably be the end of his life too. I mean, we hope, right? You hope, everybody hopes. Yes, they can absolutely be transferred to your son. They do transfer via your estate. So if you have a will, or even if you don't have just through operation of law, they do transfer that way.
wonderful. And I know there's more questions coming in, but unfortunately, we do have to wrap up. This is the last session, and the room will kick us out based on the end time of the event. So thank you so much, Matt. I know that everyone, it seems, really enjoyed it, and I'm sure got something out of it. I always learn something when I talk to Matt. So I really appreciate you taking time out of your day to come and speak to everyone. If you saw Matt's contact information was on his slides. You can find him on LinkedIn if you're looking for him, Matt Acosta. And with that, we are done. You not only closed out the legal track, you closed out all of Dallas Startup Week. So
Oh my goodness.
congratulations for that. I know. There you go. That's a new accomplishment for the resume. And with that, thank you all so much for attending. We really, really appreciate your support. Make sure and follow all of our speakers on LinkedIn and other social media. Go and check them out. And hopefully, we will see y'all next year at the Legal Track, which will be here in less than a year before we know it. So be on the lookout for our speakers next year. And everyone, enjoy your weekend. Thanks, y'all.
Take care.